Okay, Chapter 3, Part 6. Okay, we're dealing now with discovery. Okay, discovery is the process of learning facts of the case from the opposing party and from non-parties. Okay, so it's defined here as the process of obtaining information from the opposing party or witnesses prior to trial. The discovery rules are set out in the rules of civil procedure. In Georgia, they're called the Civil Practice Act. In the federal system, it's called the Federal Rules of Civil Procedure. Okay, and so the discovery rules are part of those rules. Generally, the rule is that anything is discoverable as long as it's relevant to a claim or a defense. Now, what's interesting here is, remember at the beginning of this course, I told you that there's something called a term of art. Well, relevant is a term of art in law. But in this particular case, it's almost a secondary term of art because the statutes define relevant for purposes of discovery extremely broad. Okay? So it's not the relevant, which means material to an issue in the case. Relevant is defined as anything that is material to the outcome of the case or anything that might lead to it. Okay? So for example, where you might object to a question on a deposition for saying that it's hearsay, hearsay is discoverable because it might lead to other evidence. Okay. So as long as it's calculated to lead to admissible evidence, it's okay. Now, one of the exceptions is what's called attorney work product. I could spend hours talking about this. It's probably way above your needs. It's one of the most confusing areas of law. I think, and my experience has been, that judges misapply it constantly because they don't understand it. But what it's supposed to mean is anything that is a product of a lawyer's mind in the lawyer's development of a case is not discoverable. You can't get into a lawyer's mind. There is an exception to it for rare situations where the party seeking the information cannot get that information any other way and it would unduly prejudice that person. So that's what the attorney work product is. Because of its confusing nature, I'm not going to spend any more time on it, just so that you know basically what it is. Okay, so the law sets forth several discovery processes or discovery procedures. So they are depositions, interrogatories, requests for admission, requests for documents, objects, and the entry onto certain property, and requests for examination. Okay, so depositions are sworn testimony recorded by a court reporter and often videotaped of the parties and key witnesses. So either party can depose the other party and can depose anybody who's a witness, including somebody who is an expert and might testify in the case as an expert. Okay? Depositions are done under oath. The attorneys are present for both parties. The parties are usually present, and the deponent, the person who's being deposed, whether it be a party or a non-party. Also present is a court reporter who's a person authorized by law to take down what is said, and they do it by a method of subscription. I'm not going to get into those various methods, but you have to be certified by the state. The court reporter then takes what was taken down at the deposition and turns it into a written verbatim transcript which is supplied to the court and to the parties. So there's a record of the questions, the answers, and anything else that was said at the deposition, and sometimes there's also a videotape which can be useful where the behavior or expressions of a party are also important. So depositions are valuable because lawyers can ask follow-up questions to the answers that are given, and you can delve deeply into the facts of a case. And also because the questions that are asked don't really give the deponent, the person being deposed, an opportunity to think about their answer and compose an answer that, while true, may be not exactly forthcoming. Okay, the downside of depositions is that they are expensive. Time consumed by lawyers, the court reporter costs, etc. Alright, interrogatories are written questions that one party sends to another party. So note that they're limited to the parties. Many courts restrict the number of interrogatories you can send to the other party. Okay, so that's one of the limitations. Many courts have what they call mandatory interrogatories or mandatory discovery. So they have a list of questions that each party has to answer within so many days after the answer is filed. The purpose of that is to do away with the necessity of having the same interrogatories always sent by each party. So the court sort of performs that function. You can still do further interrogatories if you would like. Okay, so the good part of interrogatories is that they're cheap and simple. And many lawyers have what we call canned interrogatories for different kinds of cases, so you don't have to spend a lot of time thinking about the questions you want to ask. The downside of interrogatories is that they give the other side an opportunity to think about how they're going to answer the question and perhaps answer in a way that's not as forthcoming as it should be, and that the number of interrogatories is limited, usually by court rule or by statute. Okay. Requests for admission can only be used against parties, just like interrogatories, and basically they are requests to the other party to admit a fact or deny a fact, or applying a fact to a theory of law to admit or deny that. Okay, so these have limited usefulness. They're usually used at the end of the discovery period in order to firm up certain things that have already been discovered and to eliminate the need to prove them at trial. So, for example, if you've got a case involving certain correspondence, say a letter of January 3rd, that's been produced in discovery in one of the methods we've talked about or will talk about, you can attach it to a request for admission and ask the other side to admit or deny that it is a genuine letter that was sent from one party to the other, etc. That avoids you having to prove it in court. All you have to do when you get to court is introduce it into evidence and say to the judge, Your Honor, I'd now like to introduce Exhibit A, which has been admitted as genuine in the request for admissions. So it solves that problem, and that's one of the major things with requests for admission. So the advantage of request for admission is that as the last discovery device usually used, it helps to narrow down some of the evidentiary issues that might occur at trial, to make it smoother at trial, to get things into evidence and to prove facts. And so that's request for admissions. Now the next is request for production of documents or objects and entry onto land. Okay, so this is where you can request that anybody, a party or a non-party, produce documents relevant to your case. So this is typically how you, as the defense attorney, for example, can get copies of the medical records of the injuries that the plaintiff has claimed. Okay, so you serve those requests for production of documents on that party or non-party, and they have two options. They can either actually produce the documents within the time period allotted by law, or they can tell you where those documents are and give you access to them, and then you have to go through them and copy them if you want to, or whatever. Okay, so that's requests for documents. Okay, objects are the same thing. So if you want to look at the damaged car, you can ask for production of the damaged car, or if you want to go onto land that was burned down, you can do that as well. Request for examination is the last, And this only applies to parties to a case, usually. And it's where the person's mental or physical condition is an issue in the case. And then you can ask that the court require that person to go to a physician or other professional, I guess, like maybe even a chiropractor, and be examined so that you have a neutral or an unbiased evidence with regard to the injuries, not what is being presented by that injured individual. So again, it only applies where the person's injury or condition is an issue in the case, and then you can get this examination. Okay, so we're going to stop there with that video.